Good morning, Mr. Atkinson.
Hi, good morning, Mr. Barra.
Good morning. How are you?
I'm fine. How you doing?
I'm doing pretty well for a Thursday.
Good.
Where's our judge? That's 11. I just hope this computer doesn't go on the fritz on me. I've had terrible trouble with it. It's my newest. I just got it a year ago, just off of warranty.
I
And
understood. Yeah, that happens, doesn't it?
oh, it's very frustrating.
All right. Good morning, everyone. It is now 11 o'clock. I have set a pre-hearing conference so that we can discuss some issues. Just want to make sure everybody's ready to go before I call the case.
Ready to go, Your Honor.
Ready to go, Your Honor.
Is the most important person ready? Tracy?
I'm ready, Judge. Good morning.
Good morning. Thank you for being here, everyone, on such short notice. Let me go ahead and call proceeding number 24F-0073CP. This is the formal complaint of Green Jeep Tours versus Purple Mountain Tour Company, Zachary Bugg, and Brooke Lynn Carswell. If I could first have appearances, first for a complainant.
Good morning. If it please Your Honor, my name is Richard J. Barra. That's B as in boy, A-R-A, registration number 7886. Appearing here on behalf of the complainant, Green Jeep Tours, LLC.
Thank you, Mr. Barra. Okay, for respondents.
Good morning, Your Honor. Aaron Atkinson for the respondents.
Thank you, Mr. Atkinson. All right. I'm not going to waste anyone's time. I called this pre-hearing conference because we were supposed to have an evidentiary hearing today in Estes Park. On Friday, June 21st, I received what was the second request for a continuance from Mr. Barra on behalf of complainants. And after reviewing the motion and reviewing the posture of this proceeding, I determined that there are just too many outstanding issues to proceed properly. We had motions pending. Discovery seems to still be in some kind of state of flux. And those issues need to be resolved before we can proceed to an evidentiary hearing. I want to make sure everyone has plenty of time and the opportunity to do the discovery that needs to be done and have this proceeding properly teed up for a successful evidentiary hearing. Yes, as I said, it seems to have become bogged down in some discovery disputes, and I want to make sure that all that is resolved prior to an evidentiary hearing. So yesterday, I granted complainant's motion to continue this hearing by decision number R24-0454-I. But I didn't want to waste any time. I want to get this rescheduled as quickly as possible, which is why I called the pre-hearing for today. So we are here to discuss quickly the rescheduling of the evidentiary hearing in this matter and set some deadlines that need to be moved as a result. Before we get into that, Mr. Barra, do you have anything you wanted to raise?
Yes, we earlier had voiced our request to do depositions. We were not able to do them, and we would like a sufficient time to be able to do the depositions before the next hearing.
And I guess my question, Mr. Barr, is that let me pull up my decision. So The decision setting, there we go. All the deadlines and setting the evidentiary hearing was sent out April 18th in furtherance of a pre-hearing conference that we held in early April. Now, you had indicated then that you were in Italy and out of the country in May, but and deposition deadline was set for May 15th, and I am kind of befuddled, Mr. Barra, why those depositions couldn't happen before you left. I mean, let me finish. We had the pre-hearing conference at the beginning of April. The order went out a few weeks later. So you had at least a month before you left to do this. So I'm kind of, I need to understand why you think you need more time when I think there was plenty of time already built into the schedule.
Well, there wasn't, because if you look at the various rules, and I would assume that since the PUC doesn't have a rule on timing of depositions, that we'd have to go to the CRCP. And the CRCP, if you want to do depositions with production, you've got to give at least 33 days. And that's 33 days from the date that you submit. So we didn't really have the time. We didn't have the time to do it, because we would have had to have had at least 33 days just to set up the deposition. And then, you know, sometimes a deposition at the very last minute gets rescheduled. And we just didn't have the time. We didn't. I mean, otherwise we would have done it if we could have. If we would have.
Mm-hmm. I see. Mr. Atkinson, can you respond to that, please?
Yes, certainly, Your Honor. Thank you. My response is that this case is slowly becoming one of the most expensive ordeals my clients have ever dealt with. And the deadline, much like other deadlines that I would like to discuss with Your Honor today, has passed. I've never heard a request for depositions until right now. I'm not familiar with a CRCP requiring 33 days notice anyway. Had there been a concern for this, it should have been raised a long time ago. And like you've pointed out and we pointed out in Todd versus Bear Valley, a continuance of the trial does not necessarily mean a continuance of all the other deadlines that pertain to case management. And so we object to several extensions, but for the purposes of this discussion, we definitely object to an extension of the discovery deadline for anything other than what has already been served on us and we're dealing with.
Thank you, Mr. Atkinson. Mr. Barra, did you want to respond to that?
Yes. First of all, my client pointed out to me that we did not object last year when Purple Mountain asked for its hearing, which on its application case, which was originally scheduled for July, to be postponed into September. And we feel that we had originally asked that this case be postponed into September because my client has been incredibly busy and is always been. This is the 3 months where the
she filed the complaint, Mr. Barra.
I know we filed it back in February, Your Honor. February.
Right.
So why are we still here in June? Because number one, we haven't gotten discovery. I attached to the motion that I filed this morning a copy of the letter I sent Mr. Atkinson outlining everything that we still needed. And it's a laundry list. They've probably given us about 25% of what we've asked for, even with your order. And without your order, we didn't get anything.
Yes, well, that came in this morning. I read the motion. I didn't have time to read the attachment. So let me see if I can quickly pull that up. If you give me just a moment.
And what we still need is, if you want to skim down to the second page at the bottom, there's a whole list of everything specifically that we still need.
Okay. When was this letter sent, Mr. Barra?
What's the date on it?
I don't know. I'm trying to pull it up and my system is slow.
I believe it was the 21st. No, 4th.
The 20th, Your Honor.
The 20th. Thank you, Mr. Atkinson. Here's the thing, Mr. Barra, that I'm finding extremely frustrating. And I'll be honest. This procedural order setting this matter originally for a hearing and setting the procedural schedule, as I indicated, was set out sent out in April, after a pre-hearing conference held in early April. Those deadlines were set in there, and at no time prior to those deadlines or up until now have I seen any kind of a motion asking for an extension of time on any of those. So to sit here now, after I've granted a continuance and say you suddenly need more time to do discovery when those deadlines expired, what, 6 weeks ago? Seems
Well, Your Honor, if
inappropriate.
I may,
I'm not done, Mr. Barr. It seems inappropriate and unfair to the respondents. You're dragging your feet, and they need to have closure on this, and it's been motion after motion and costing everybody time and money.
all right. Well, first of all, you asked for a statement of position back in prior to the pre-hearing conference. In that, I specifically stated I was not available for the whole month of May, and June was very tight for me as well. I reiterated that at the pre-hearing conference, and yet you went and set all these things right smack dab in that era time when I was not going to be in the country. So, I mean, it's not really my fault that things didn't get done when I told you that I didn't have time to do them, and you set things in. I would say I felt like you did it on purpose. I'm sure you didn't, but that's how it felt to me.
Well, I mean, my job is to keep things moving, Mr. Barra, and setting things, 6, 7, 8 months down the road is not accomplishing that goal.
That's what my client points out to me, is that the commission was able to set the application in Purple Mountain out to September, but why can't she get the same courtesy on her case? And she'd like to know the answer to that. And I can't give her an answer to that.
Mr. Barra, I was not involved in the application.
I know.
And I don't even know when that was filed. I don't know when that was set. I don't know what the deadlines were for it. I don't know any of that. I don't know what the statutory requirements were or what the timeline you fell under. But you are, bringing these claims against Purple Mountain, which has now been issued its CPCN, I should note, and asking them to continue fighting some issues that were addressed by that CPCN. So I would like to bring this to a close as quickly as possible. And while I am willing to extend some deadlines, I do not think it's fair to respondents to extend others when, from what I'm hearing from Mr. Atkinson, is no requests for depositions have even been made, right? I mean, you say you want to do them, but you didn't even ask to have them done.
Because the deadline had expired. The deadline expired, so what's the point of trying to seek something that you can't do unless
the point is, Mr. Barra, to get things lined up properly. You could certainly have at least made the request and then asked me for an extension of time, but that didn't happen. Instead, I'm hearing about it 6 weeks later when, suddenly it's an all-fired emergency, and I'm a little verklempt that we're dealing with this at this late stage. I have granted your request for a continuance. That can happen, but I don't know that I'm very much disinclined to allow additional discovery at this point. Besides, I know you have exchanged some discovery requests. I've gotten the motions for protective order and motions to compel and whatnot. So that has happened. So if that could happen, I'm not seeing why a request for deposition couldn't have also been made.
Well, first of all, we sent out our discovery on April 25th. If that discovery had been responded to, which it still hasn't in its entirety, we wouldn't be here today.
Okay, that's fine. And that is, well, no, we would have been here today because we would have been having an evidentiary hearing.
Well, we would have been in Estes Park.
Correct. So
I want to point out, I'm sorry, please, I didn't mean to interrupt you, please.
No, go ahead, Mr. Atkinson.
I was just going to say, I want to point out that let's be clear. We answered discovery timely. We also filed a motion for protective order in regards to certain discovery requests that we found onerous and burdensome and what have you. But to say that we didn't participate in discovery timely and in accordance with the rules is just wrong.
No, I didn't say that. I said we didn't get the discovery. I didn't say you didn't respond. You responded in a timely fashion, but everything was objected to. So, I mean, yes, technically you responded, but we didn't get any benefit out of it. We didn't get the discovery we asked for. So you can play all your procedural games, but we didn't get our
Those are
discovery.
not procedural games, Mr. Barr. Please, let's not call things what they're not. Okay. All right. I'll be honest. I am not persuaded, Mr. Barr. At this point, I think if you wanted to do depositions, that request should have and could have been made long ago. I'm curious, how long were you actually out of the country? You keep talking about May. Were you out for the entire month?
No, I was out for the first half. I came back for a weekend, and then I went to San Francisco for that very important immigration hearing, which you
Right.
minimized, which I really got upset with, because I felt to myself, if it was your brother, your son, maybe you'd feel a little more compassionate to my client.
Mr. Barra, please do not go there. My family were refugees. My husband is an immigrant, so I truly do understand what an immigration hearing is like, and I do not accept, I'm offended by and resent that kind of a comment. I did not minimize it in any way, and I would kindly ask you to take that back.
I'll take it back if you take back what
No.
you said.
No, stop, Mr. Barra, before you dig your hole too deep. Okay. Here's the thing. During all of that time, I think you had plenty of an opportunity to ask Mr. Atkinson for some depositions if you wanted that to happen. For whatever reason, that never happened. And it still has not happened today. And it is now the end of June. So long after your immigration hearing was done, long after the deadline had passed, you haven't made that attempt. So I'm sorry, but I'm not going to allow that. There's not going to be any more discovery. That, even if you had wanted to do more, that request could have and should have been made quite a while ago. However, we do need to nonetheless reset the evidentiary hearing, and I still would like, and will set deadlines for exhibits and witness lists, because those seem to be deficient and are hampering my ability to prepare for a hearing. So,
Your Honor, it's hampering my client's ability to give you the exhibits. Well, we can't get them through discovery. So that's where we are. And that's why we asked for the continuance, because we haven't got, 3 days ago, we got 5 pages of traffic studies. Why didn't we get them back on May 6th?
I can't possibly answer that, Mr. Barra. I ruled on motions for protective order and motions to compel. That is your vehicle if you think something is incomplete. So that's all I can do. That and set some deadlines. So here's what I propose. You clearly have received some discovery because you filed a motion for summary judgment yesterday with a bunch of documents attached.
Right.
So
that's all we have.
Okay, so you've got that. And I have not looked at it very carefully yet. And there are parameters to the discovery in this case that I've set, because what happened after the evidentiary hearing in the CPCN case is not at issue here. Right.
I believe you meant the reverse, because you ordered that the discovery start after the close of the evidentiary hearing in the application.
Because anything that happened prior to the evidentiary hearing in the CPCN was addressed in that proceeding. So we are talking about discovery post evidentiary hearing in the CPCN. So my proposal is complainant could files its exhibits and witness and exhibit lists. All of that needs to be filed. The exhibits and the lists by July 12th.
That's, Your Honor, that's impossible. That's impossible, because we don't have anything right now.
So, Mr. Barr, you list what you have so far. Is that not the point of it?
If that's not the final one, yes, that's fine.
If you let me finish, 2 weeks later, respondents can file theirs. They have already filed something. They file theirs in response along with exhibits, which I don't think you did file, Mr. Atkinson. Exhibits do need to be filed as well.
Understood, Your Honor. So I have my apologies for that.
Thank you. And then Mr. Barr, complainants have an opportunity to supplement their exhibits and witness and exhibit lists following the respondent's disclosure. I would have that done by August 2nd. All right. And then looking at the commission's calendar. Oh, one other deadline I would like to move is I would set a deadline for stipulations and settlements by August 9th. And then looking at the commission's calendar, because it is pretty full, but Tuesday, August 20th, there doesn't appear to be anything on the commission's calendar. So I would propose Tuesday, August 20th for the rescheduled evidentiary hearing. Okay.
And my client would like that in Estes Park.
Well, then your client will have to call the library and see if she can arrange it, because the commission staff is swamped and your client is the one with the library card who has access to it. So let's set it for August 20th. I will right now set it. Tell me your preference. Would your preference be hybrid in Denver or fully remote?
Well, no, fully in person.
It would be hybrid because it's easier for the commission to do exhibits on electronically. So we'll have to use that. And that way, if somebody can appear in person, they can appear remotely. But I am happy to do hybrid. Mr. Atkinson, what is your position?
Your Honor, again, not to keep beating the same drum about how expensive this is, but in light of that fact, I would like the continued hearing to be virtual.
Well, yeah, but that's why I'm suggesting hybrid, Mr. Atkinson. That way, if Mr. Barr wants to be in person, he can do so in the commission's hearing room. I can be there in person with him. But you and your clients, if you want to appear remotely, can do so. We have great connection, great screens, and it's really no problem to do it hybrid.
And if it's a hybrid model, Your Honor, and it's the people who wish to be in person, are we saying it's downtown, or where exactly are we looking?
Yeah, it would be downtown at the commission's office in the commission hearing room. We have all the equipment, all the technology set up there for it.
That was, if it can't be all virtual, then hybrid is fine, and downtown is what I would prefer.
Okay.
I'm
All right,
not.
Mr. Go ahead.
We want an in-person hearing in Estes Park, and I need to be with my client. I can't be down in Denver and my client in Estes Park. That's not going to work. I can't give my client adequate representation, and that would be an immediate appeal right there.
Okay. Well, first of all, your client is welcome to join us in Denver so that she can be in person.
No,
with
she
you.
can't.
But Mr. Barr, stop. Holding it in Estes Park, we had it set up in Estes Park. We jumped through a lot of hoops to try and get that to work. Not least of which was having your client go and get the library card and set it up, because we don't have that capability. We don't have the money, the funds. The commission does not have the funds to just be holding it anywhere in Estes Park. We have to find a space, and we have to try and find a space that doesn't cost the commission any money. Fortunately, the library does provide that option. So if your client really wants to have it in Estes Park, I suggest you or your client call the library and see if the library is available on Tuesday, August 20th to hold a hearing. If that's possible, please contact us immediately. And I am not averse to doing that. Okay. But I am averse to having my commission, my staff, again, jump through a million hoops to try and set that up. It took a lot of time, a lot of effort, and we are buried. And I simply do not have the time or the resources to try and make that work. So if you want it in Estes Park, please go ahead and contact the library and see if they are available on Tuesday, August 20th.
Are there any alternate dates just in case so that we could set it right then? Like the week of the 20th or the 27th?
I am not available the week of the 27th. I have a big hearing that week, so that doesn't work for me. I would say possibly Thursday, August 22nd.
Okay, and at the same time, like we did before, 12, starting at 12?
Ideally, I will tell you that the one reason, we can't start it too early. If you want me to get up to Estes Park
right,
without the capacity to spend the night, we can't start too early.
Right.
I think the earliest we could start the hearing would be about 11. The reason I actually set that to start at noon was because the room was only available from 11:15 a.m. to 4 p.m. So we took it. That's all the time we had. And I wanted to start at noon to try and give us a full 4 hours to do that. So if it's available starting in the morning, I think I could get up there as early as 11 or maybe 10:30 to start at 11, but not much earlier than that, to be quite honest.
No, and my client wants to keep the cost down too. She doesn't want to have to pay for my being in Estes Park either. I mean,
Right.
everybody has to keep
Right.
costs down.
Right. So, like I said, you're welcome to call and see what you can.
We'll be happy to do that.
Okay, and then please, let's just do that informally. And if you are able to do that, I will. Please email me and Mr. Atkinson, and we'll take care of it that way. I think we can do that informally. But if it's not available, I do intend to go forward on the 20th with a hybrid setting, whereby whoever wants to be in person in the commission's office can do so, and whoever wants to be remote can do that. And I will honestly tell you, Mr. Barr, it works extremely well, and it doesn't harm the process in any way. In fact, I think it's so much more efficient for many, many reasons.
Well, I beg to differ with you because I had a case in Denver, and it was during the pandemic, so we were forced to do it. My client was in his office. I was in my office. The judge was in his office, and it was a mess because we couldn't get documents.
We've got it pretty down now, Mr. Barra. Honestly, we've done them so many times. Our legal assistants are extremely adept at getting the documents filed, pulled up, and on the screen to be shared with everybody for anybody who's remote. But like I said, if we do it hybrid, you'll be in person anyway. We will have to have the documents electronically available, though. And the way they do that is our legal assistants send out a folder through a website called box.com, and they just have you upload them into the folder, and then they can easily access it and mark it and manipulate it and do whatever you want to it. Make sense? But it does, I assure you, it works extremely well. It really, really does. And in fact, you are one of the few attorneys who actually ask to do things in person. Most people nowadays just want it remote.
Oh, if it were for me, for my own pleasure, oh, I love this. I'm in my own office. It's nice and cool,
Exactly.
70 degrees. I don't have to be out in that crud. But
yeah,
I have a duty to my client.
I understand, Mr. Barr, which is why, like I said, right now I've got it. I'm going to send out an order when I get my other backlogs taken care of. And I'm going to shoot for a hybrid on Tuesday, August 20th. If you can arrange to try and get the library that day, or possibly the 22nd, those are the only days really that'll work.
Okay.
Let us know, and I'll send out a modified order affecting
I'll
that.
do that.
Okay. Okay, so we are all in agreement by the dates. Do you want me to go over them again so everybody can mark it down?
Yep.
Okay, I've got complainants, exhibits, and exhibit and witness lists by July 12th. Okay, tell me when you're ready.
Yeah, I'm ready.
Respondents' exhibits and witness and exhibit lists by July 26th. Okay. Then complainant will have an opportunity to supplement its exhibits and witness and exhibit lists by Friday, August 2nd. All right. Any stipulations or settlements that the parties may reach should be filed by Friday, August 9th. We will set a hybrid hearing for Tuesday, August 20th, starting at 9 a.m. That will be in the commission's offices in Denver, with the opportunity and the ability for people to appear remotely if they so choose. And then last, I didn't think I mentioned this earlier, but then any statements of position following the evidentiary hearing would be due by Friday, September 6th. Okay. Did everybody get all those?
Yep. Thank you.
All right. All right. Wonderful. One other issue I wanted to raise is, Mr. Barr, I saw your motion that you filed this morning to modify my decision, and
Yes.
I'm honestly quite baffled by it, since the first sentence of Rule 10 of 1001 says that the Colorado revised statutes and the rules of practice and procedure shall apply. So
No, Title
CRCP
40 shall apply.
Well, the rules apply to the extent there's not a conflict. That's basically what it means. So that's my understanding. And
Well, are we looking at the
quite
same?
frankly, Mr. Barr, I don't know why you bother. It doesn't matter. Even if you disagree with my interpretation of the rules, I granted your motion. So I'm not inclined to modify a decision that a change that I think is not even correct, and B, to have Mr. Atkinson spend time and money responding, and me filing a decision on a motion that's inconsequential, given that I granted your motion.
Well, it's not inconsequential, because this time you granted my motion, but that doesn't mean going down the road that I'll have the same fortuitous luck, because the rules, the way my statute book says Title 40, it doesn't say all the statutes, and it specifically lists the rules of civil procedure separately and distinctly, saying that they're precatory, they're not mandatory. And
Well, you be on notice, Mr. Barra. I look at the rules, and I may employ them. So if I were in your shoes, the safest bet is to take a look at the CRCP and see what it says. And if it's not different than our rules, I'm going to follow it, because I think those make things easier and cleaner for everyone to follow. And I would note, just for everybody's edification, if you look at our rule 1004, subsection H as in house, CRCP means the rules of civil procedure as they were published in the 2012 edition of the CRS. So it's not the current version, but Rule 121, Section 1-11, I looked it up, and it was amended and adopted in 1994. So it was in effect in 2012. So it's just good practice anyway, Mr. Barr. I'm going to issue just a one-page something saying that I'm going to deny it. Mr. Atkinson, I'm waiving response to it. You don't need to. I'm not changing my order where I don't think it's necessary. That's just a waste. I'm not wasting people's time that way. I'm sorry. Okay.
All right. Well, I accept to it. And if there's an adverse decision, that's a point of exceptions and appeal.
You're going to appeal a decision on a motion that you won. Really?
No.
If you want to do that,
I didn't say that. I did not say that. I said if the ultimate decision does not go in our favor, it's an element of our appeal, is what I said.
If you want to throw it in there, but honestly, I don't think it's going to be your strongest argument.
Well, Your Honor, I beg to differ, because we had a similar situation in Denver County Court where the judge refused to do the appropriate rule. And we went through a whole hearing based on a different evidentiary standard. And of course, our side lost, so we appealed it. And district court kicked it out, saying the judge used the wrong standard. We have to start all over on using the right standard. So it does happen.
That's fine, Mr. Barr. That's not what we're talking about here. We're talking about a motion you won that I granted. So even if I'm wrong, and I don't think I am, because I'm allowed to follow the CRCP, what difference does it make? I'm just saying.
No,
so
I'm looking prospectively. I just want to protect my client's interests.
Okay.
I'm zealously regarding my client's interests, and that is what you do. If you think I'm overboard, well, that's fine. I'd rather be overboard than underboard.
All right. Okay. Anything else, Mr. Barr, that we need to address today?
Let's see. I think that is, Now, if, no, I guess we have already addressed it. We did.
What, address what?
The depositions.
Yes, I'm sorry, but I think you had plenty of opportunity to ask for them. And it seems from what I'm hearing that no request was ever made. So I would have considered a request to extend that deadline, but none was forthcoming. So
Well,
at this date, no.
I'm going to have to answer to my client because she wants to do depositions. And so rather, we're trying to keep costs down. So I'll probably have to file a motion for reconsideration or whatever to do the depositions because she's going to be upset with me that I didn't get depositions for her. So perhaps since we've got plenty of time between now and August 20th, we've got the 30, I said 33, I meant 35 days. We've got the 35 days. So if we did it now, we definitely have the 35 days. If I have to file a motion and finally you decide to do it a month later, then we're coming up against deadlines again. So that's just the point that I would like to raise on that.
All right. Mr. Atkinson?
On the same topic, I don't follow the logic, but I do have another. Would you like, Your Honor, to hear the other items that I had on my list, or are we still talking about the depositions?
Let's just talk about the depositions first, and then I guess stuff. I mean, I'm being presumptuous here, Mr. Atkinson. Does your client want to be deposed? Do you want to have depositions in this matter?
As you well know, Your Honor, the two most expensive things in any case are depositions and dispositive motions.
Yep.
And so, no, we don't. I mean, I would have happily presented a deponent who's my client if it had been requested. I would have probably consented to an extension of the deadline if it were asked in accordance with Rule 6. None of that happened, and now it's brought up for the first time, and it feels like in the last 7 days, the basis for the motion for continuance was that I don't have enough time to prepare, and yet somehow we have enough time to draft 5 motions that I have to marshal responses to, which I find dubious. So, no, we object to depositions.
Okay. Thank you for clarifying that, Mr. Atkinson. All right.
If I may respond to Mr. Atkinson briefly.
Of course.
Yes, we filed 5 motions because I stayed up all night to do them. And I would have been able to use that time to produce evidence if I had it, but I didn't have it. That's the problem. So, the idle hand is the devil's workshop. If you had given me the discovery instead of drafting these motions, I could have been doing productive work in producing a witness list and exhibits. So that's all I have to say.
Okay. Thank you, Mr. Barra. Anything else any other issues you want to address, Mr. Barra?
No, we're done. We're done.
Okay. Mr. Atkinson, what issues did you want to bring up?
Your Honor, we have a continuance of the trial date. The continuance of a trial date does not in and of itself continue any other dates unless specified by the commission.
Correct.
My client has a very, very big problem with 5 motions to respond to, one of which is dispositive, and all of which were filed after the June 7th deadline for pre-hearing motions. I understand. I can understand that if we cannot get on the same page with a discovery dispute, because obviously Mr. Barra thinks we haven't given him anything, and for the record, we can believe the complete opposite. But charging my clients to respond to these other motions when there was no request for an extension of the pre-hearing motion deadline, when there's no basis for them, when the time period has passed, it's an expensive enterprise that is not necessary. And frankly, it doesn't waive any rights because he can still bring up the same arguments at the hearing that he brought up in the motion for summary judgment. But we can't get the money back. And so I object to, I would like to ask the commission to deem those motions past the deadline and to deny them without necessitating the respondents the obligation to respond to them.
Yeah, I appreciate your position, Mr. Atkinson. I really do. But honestly, I can't grant that at this point. I haven't even read them and digested them carefully enough to figure all that out. I do note that there was a pre-hearing motion deadline that expired and that complainant's motion for summary judgment was filed after that. But I haven't yet had a chance to weigh how much of that is responsive to respondent's motion for summary judgment. So at this time, I'm not willing to do that. I leave it up to you whether you want to file a response or not.
Understood, Your Honor. I think those are the only. Well, I guess they're along the same lines. Without sounding cheeky, are we done, or are there? Is the motions practice over? Can we all agree there won't be any more motions unless they're directed at something unexpected?
If you're asking me if I was going to extend the motions deadline, I was not. I did not. That is not one of the procedural scheduled issues that I reset. We had a pre-hearing deadline. There are many motions pending right now. And quite frankly, I will say this to both of you. If you file any more motions, I don't know that we'll make August 20th because there's just one of me and I have to read them, assess them, rule upon them. And if you want me to do that before the hearing, that's my plan right now. But if you inundate me with a whole bunch more, I'm not sure I'm going to be able to get to them all. So no, I was not planning on resetting the motions deadline. That has come and gone. And I'm just giving you a little bit of extra time so that you can clean up whatever discovery needs to be cleaned up, finish off the motions, practice of the motions that have already been filed to whatever extent you need to, not filing any new ones, and then getting all those ducks in a row so that that can all be completed before the hearing. I'm just trying to give us a little bit of breathing room because things got a little bit more constrictive than I had hoped.
Understood, Your Honor.
All right.
Thank you. That's all from the respondents.
Okay, thank you, Mr. Atkinson. Mr. Barr, anything else?
Yes. Based on what we've just discussed, I am concerned that you are going to just out of hand deny my motions. And I think that would be totally unfair because most of them were done because of surprise. They weren't held back.
Well, Mr. Barr, let me consider it, weigh it. I mean, I don't think you can dispute that there was a deadline and that, post-dates it. I have not considered it, and I cannot tell you exactly how I'm going to rule on it yet at this point. So it's actually quite, I cannot give you an answer to that. I will consider it, and I will rule in an appropriate manner.
Well, if a pre-trial motion that hurts my client's position is, if denied, hurts my position, if denied, then obviously I'll have to file a motion to set aside under 1502. So there we have more motions.
I think you're getting ahead of yourself, Mr. Barr. I really do. Let me weigh it all. I haven't even had a chance to really read it all. It only came in yesterday. So let me do my work to consider it, and then we can take the next step. But let's not cross that bridge before we need to, okay?
Okay.
All right. Anything else, gentlemen?
Nothing. Thank you, Your Honor.
All right. Thank you both for being here. I beg your pardon?
I think maybe we're finished.
All right. All right. Thank you both for being here. Thank you for being cooperative and for coming up with dates. I will get a rescheduling order out as soon as I can. And I will wait to hear from you, Mr. Barra. See if you can set it. But like I said, I'm going to go ahead and get my decision. And if we need to modify it, if something happens, great. But otherwise,
I'm under marching orders to talk to my client immediately after this hearing is over. So we'll probably have an answer for you by this afternoon. I'll try to anyway.
All right, great. All right. Thank you so much. Thank you both for being here.
Take care now. Bye-bye.
We are adjourned.